The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. You can watch our program on Mediacom Channel 15 here in the greater Des Moines area. This program is aired on Sunday afternoon at 1 o'clock, and again it's repeated on Wednesday evening at 9:30. You can email us at vocaliowa@mchsi.com. My telephone number is 515-276-3956, and John's phone number is 515-282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. CPI, that stands for Child Protection in Iowa. That's our topic of interest. Our mission of interest is to assist people who are having difficulties with the Department of Human Services on child protection issues, and also we sometimes are of help to people who are working in the juvenile court. But for your benefit, we are not attorneys. We do not hold ourselves out to give legal advice as attorneys do. We're just individuals who are attempting to give assistance, knowing a little bit about the law, giving you some hints of what we would do if we were in your shoes. And we've seen some pretty difficult cases. We've solved some pretty difficult cases.
And you forgot the disclaimer about not practicing law.
Yeah, we don't practice law without a license. If I were asked to practice law, I would say no. I would like to do it right the first time.
Have you ever seen the license, John? I've never seen a license.
I've never seen a license either. I think it's something of someone's figment of someone's imagination.
They've never offered me one.
I've been accused of practicing law without a license, which probably is a compliment because it means I must be frustrating the situation enough to think that they believe that I could say something of interest to a client. Well, sometimes people that give hints like we do we get in the way of what the bureaucracy and the paid attorneys are doing.
The money is the issue. I think they might lose a little money, and they don't want to lose that money.
That's correct. And also, when you're handling a case as an attorney, you probably don't want a whole lot of interferences. There are some clients that are difficult to work with as it is. And if you have a client who's listening to a number of voices, it might be a little more difficult for an attorney to cope with that. There are some attorneys whom I have a good deal of respect. I think I could count them on my left hand without running out of fingers. But there are some attorneys that deserve some respect. Those are attorneys who know what they're talking about, and they are willing to listen to what a client has to say, and they are willing actually to show up at trial time. They are willing to give some hint as to what papers they are receiving from the court. One of the problems that you have, and this is not to say whether or not you engage an attorney, but one of the biggest problems we notice that the people that we work with who are tied up with an attorney one way or another, sometimes they're court appointed, is that once you do that, all information flows to the attorney and not to you. Now, you are as a parent, are the individual who knows the most about your case. You know more about your case than anyone else in the world. And why that information should not flow past you, I do not know. They want to keep you in the dark, and they don't want to waste too much paper on the client when they can deal with the attorney. And I think it's easier to deal with the attorneys because they can make deals. And I've heard all too often when the attorneys all gather along with the social workers and everyone else into the back room. The back room of they call chambers in district court is not the place for a public hearing, but they can make all kinds of deals and decide what they're going to do with that client that's sitting out in the courtroom. They make all the decisions, and then when they come out, they say, well, the parties all being in agreement. Excuse me? I was in agreement with something when my attorney was chit-chatting with the prosecutor or with the county attorney or with the state's attorney. Excuse me, I didn't agree to anything. So kindly remind me what it is that I agreed to. Well, I think there is a real problem here in communication. You had a comment, Don.
The parent is the one that knows the case you were talking about earlier, and then you mentioned that the paperwork does not flow to the parent. It just goes to the attorney of record. And so at that point, the parent gets ignorant about what's going on. The whole case turns around from what actually happened in the home to a new thing that the court system is starting up. Let's see. Santosky versus Kramer. The DHS has the power to create history. That history starts when the court system, the attorneys, the therapists, all those DHS workers get involved. And so the picture just totally changes, and the parent is left in ignorance. Most parents don't have any idea about what paperwork is being shuffled around and how that's going to control your future. John?
One thing that one other barrier, in addition to this blackout that the parent gets when he gets tied in with a court-appointed attorney, or even if he hires his own attorney, one additional barrier, and there's several, come as a result of prosecutors getting together in associations, countywide, statewide, and across the nation, dreaming up new schemes, ways of approaching certain kinds of problems. One other barrier, and we won't have time to talk about that today, is a barrier which deals with science versus junk science in the courtroom. We have people who are willing to deal with junk science as expert witnesses, and of course the judge has no reason to discount a junk scientist, would he or she? Because after all, they are experts. And unless you can hire an expert witness to counter the junk science witness, you're pretty much in trouble. Let me talk about one other area that is a real barrier to families that we work with. And this is in the fact that, first of all, the structure of our government, structure of our laws. There's nothing particularly wrong with the structure, but when prosecutors get a hold of it and rewrite it, then we find some problems. The statute on denial of critical care, failure to supervise, is, as we said, the largest accounts for the largest number of child abuse reports in Iowa, and it engages over 204 social worker 3s whose job is solely writing up reports. Now that is a massive force of people writing up child abuse reports. Okay, now from the structure of the statutes, which are passed by our legislature, assumed to be constitutional, because, after all, they bear the cloak of constitutionality simply because they were passed, and until they're challenged, they are considered constitutional in their nature. Then it's signed by the governor and goes in the code. No part of the code, the Iowa statutes, which is now contained in 5 very fat volumes, is changed more than the code with the Department of Human Services. That's 235A and 232 chapters of the code. I once said it probably would be wise simply to write it on the chalkboard and then go down and erase the parts that you want changed, because they're changing it so rapidly. And it's hard for me to keep track of all of those changes. Okay, now once you have the code down in statute form, it forms a skeleton for the way government wants things to be run. It doesn't do all the detail work, because the detail work is then found when the various agencies that are concerned will write administrative rules, and those rules have to be passed by a legislative committee called the Legislative Review Committee, and they meet once a month. And when they want to make changes to the administrative rules, it's fairly simple, and in some cases they do it on an emergency basis, and they can pass it through lickety-split, and basically rewriting. If they do a poor job, they're rewriting what was once a part of the statute. You may not even recognize the statute by the time they rewrite the administrative rules. Then one other thing that they get into is something called department policies, and they look like something like this. I don't know if we can get that up on the screen. Yeah, we can. This is what the department comes by and writes. So, in the statute, and by the way, they do make reference to the subsections and so forth of the code, so that you know the point at which they are springboarding things off in the code. So we know in this case that it arises from 232.68 of the code, and then if you want to find the administrative code, it's 441, 175.21 of the code.
So this has to, the information you had up there has to line up with the Iowa code.
You say has to? That sounds like mandatory. If it has to, we would have no problem. But these people seem to like to write things the way they want them written, and when you can do that, when you have all kinds of authority to rewrite stuff, and if nobody challenges it, and of course department policies, there's not much of a way to challenge it. Department policies are overseen by the Council of Human Services, which is appointed by the governor, but I've never heard them take up whether or not they want to pass certain policies. These are just written by the hotshots in DHS.
It's like
they basically fill in the blanks. So
yeah, right.
But sometimes they overstep their authority.
And I'll give you some hints about how that's done. Denial of critical care. Well, let me go back to the basics. Here's what the legislators say that they want for child protection. They believe that it is incumbent upon parents to provide shelter, to provide clothing, to provide food, to provide medical care, those kinds of basic things for children, to the extent that the child is not injured or the child doesn't die. Now that's their basic tenet. So anything that a parent would do in terms of denying shelter or clothing and so forth. So now the department wants to come back and say, how can we tweak that so that it isn't quite as restrictive, so that we can tie in more people? Well, here's the way it's done. It's done with their departmental rules, and they can stretch words like care and so forth. And one of the words that they love to do, they decide what is appropriate by what a reasonably prudent person would do in the same or similar circumstances. Well, who do you suppose they appoint as a reasonably prudent person? Well, the person who's making the accusation, the social worker, would be the reasonably prudent person. And so he or she stands as the basic standard for what is and what is not child abuse. So the social worker, for the most part, is judge, jury, and executioner. Sounds like a pretty good job, doesn't it? And try to try as you may, it's difficult to get them off of their perch. Okay, what they do is that they go through a whole bunch of things here to illustrate, and as necessary, they add to it. By the way, when they add to it, they put lines down the side to show what the newest deal that they've been talking about. Now, can you see those vertical lines? Those indicate where the new stuff is. By the way, these can be found on their website if you look at the rules. Okay, and they also like to give examples of the kinds of things that they would find as abusive. For a situation to be assessed as denial of critical care, there must be a reasonable belief of the following: that circumstances occurred or exist which indicates a failure to provide adequate food, shelter, clothing, or other necessary care. Other necessary care now completely covers the waterfront. Anything that they think is necessary now is included. And if it isn't given, then this person is a child abuser. So watch out for shady terms like that. They use the standard of adequate for the child's health and welfare. Health and welfare, those are pretty shaky terms too, aren't they? The child's welfare. Who can say what the welfare is? If you can't find it in the statute, it's not there. I'm sorry. Okay, here you're supposed to find the parent guilty if the child's lack of weight gain or loss is due to the lack of food. If there is no food in the home, do you suppose you could ever go to the home and find no food? That's the day they go shopping, isn't it? Why would you want to go shopping if there's food in the house? The food is contaminated or spoiled, resulting in physical ailment, or the child is suffering from physical conditions or disease resulting from nutritional deficiencies. How does the social worker know that? Well, the social worker needs the junk scientist to come in and help. The reporter indicates this person is an abusive parent if the child has no home. By the way, we found 3 children in Scott County who had no home. Their new home hadn't been finished yet, and they were living in a motel. So the DHS wrote them up, sent them to juvenile court. The father lost the 3 children because they had no home. All they had to live in was with the local motel. The child lives in a home that lacks heat in the winter. Well, that makes a little sense, doesn't it? The home has unsanitary conditions such as toilets are not functioning. Boy, you'd better make sure the toilet works. An overflowing amount of trash or garbage or spoiled food that can be accessed by children, or infestation of cockroaches. Boy, you better put up a sign so those cockroaches don't enter your apartment. The house has structural damages such as broken steps or missing railings, large holes in the ceiling or floor. I don't know what the size of those large holes should be. Maybe they should specify. Windows or doors with broken glass. the home has hazardous conditions such as exposed or frayed wiring, um, fuel containers stored in living areas, um, paper or clothes piled near a heat source. Boy, you better watch it on laundry day that you don't have the clothes piled near the register. Chemicals or drugs within easy reach of the children. Okay, the reporter indicates the reporter is the stooge that picks up the phone and says these kids are being abused. If oh, the child does not have a winter coat during a blizzard, uh, and catch this one. This is the one that really caught my eye. Footwear that is too small or too large. Can you imagine with growing children that the footwear that they have would always be precisely the right size for the children? How about the poor 4-year-old that waits to get new shoes until the 6-year-old outgrows the one that the 6-year-old is wearing?
So you
Well,
also have to have a pair of shoes in the morning and a pair of shoes in the afternoon because your feet change size during the
well,
day.
So
from what my grandmother used to tell me, I mean, they used to hand down clothes, you know, with a lot of kids in the family, 8 or 9 back in the 20s and 30s. You know, sometimes your clothes might not fit exactly right.
yeah,
So,
right.
according to this standard, my great grandparents were child abusers because they basically denied critical care for
So
my grandmother and her siblings.
so you come from a legacy of
Denial of critical care.
historical. Did I look at
That is very, very crazy.
Uh, well, that's the kinds of things that I look at when I go through these things. You see, that is an extension from an extension of the law that the legislators passed. Now, we can hold the legislators accountable for what they write because we can vote them out of office. We can't vote the social workers that wrote this crummy stuff out of office. But the new social worker that comes to work for DHS and is accountable to his or her boss if
So, how many sizes?
Yeah, right.
So, if it's a size too big,
Yeah. Well, it says
any size?
if the footwear. Now, I suppose that would be socks too.
So, what is the social worker going to come out with a foot measure
That's right.
and look at the shoe?
That would be
wow.
they would have to have. See, this suggests that you have to have other standards, right? Because if you're going to set a standard that the shoe can't be too large or too small, and the kid is growing all the time, that means he's going to be headed down to the footwear.
So what they're trying to say is, if the shoe fit, wear it.
And the bottom line, it's impossible for the parent to satisfy the DHS.
Yeah.
Yeah,
Well,
exactly.
and basically what I'm getting at here is that we're making extensions to extensions to extensions based upon what the legislature said was an appropriate care for a child, and that is that he has shelter, medical care, food, and housing and so forth, that he has those basic things to the extent that he is not injured or that he does not die. So if the child isn't injured and the child isn't dead, then social workers need to stay out of the way, or at least use a little bit of discretion before they write somebody up on these things. But footwear that is too small or too large, I think they're going far out of bounds to find something like that. Well, we'd better switch over because you see, once you get crummy stuff like this written up against you, they can take it into court. And if the juvenile court says, yeah, did you or did you not have shoes on that 3-year-old that should have been for a 4-year-old? Well, sure, because my 4-year-old needed new shoes, and so I gave the 3-year-old the 4-year-old shoes. So
It all leads up to termination of parenting rights and future adoption, and there's money, money, money all the way down the trail for the
you bet.
DHS.
And there's no particular reason for them to intervene in the first place. And the places where they should have intervened, I don't know if we'll have enough time for this or not, but um, because we saw a case where the DHS had an opportunity to intervene and save a little girl, but failed to do so. We're seeing case after case after case where children die while they are in um, the purview of the Department of Human Services. Their family is being seen by the Department of Human Services, but they aren't able to take care of those cases. They want to take care of the case where the kid complains because his shoes are too tight. And he didn't get the same design of shoes as the other kids over the junior high have. So
Didn't get them brand new Nikes.
um,
I could see that turning into a situation where a kid could just manipulate the whole situation. Mom, if I don't get those brand new Nikes, I'm going to report you to DHS
That's right.
because I got corns.
That's right.
Sometime I need to read the email that I got several years ago, actually, about a boy that demanded all these things because the school teaches kids that they have all their rights, and then mom comes back with a response to all this. So sometime I'll read that.
Okay. One other thing I better mention on this same sheet is when the school teacher says that that little troublesome Billy in third grade needs to go see a shrink. And if mother doesn't take him to a shrink, that is denial of critical care because the teacher said that he needed to see a shrink. I think if you can't find it in the administrative rules and you can't find it in the statute, then I think the social workers need to hang up these silly rules that say that the school is going to behave in accordance with what what the DHS workers want, and the DHS workers will see to it that the child is taken to court and made a ward of the court, taken away from the family that loves him, and put into foster care, in which case he is 8.2 times more likely to be abused than he was when he was left in his home. So he'd better put up with the tight shoes. He better put up with the problems of not being able to see a shrink, because he's probably better off home with mom and dad than he would be in foster care.
And them
right,
tight
John?
shoes.
Yeah, and tight shoes. Yeah, right.
And further, John, when a child is put into foster care, a lot of these children end up in prison later in life when they become adults. And I was just talking to a mother yesterday that her child was taken from her for false accusations, and later the child came back. When the child was 18, he didn't want to be away from his mother. He didn't reject his mother, so he came back. And of course, at age 18, you can't stop a child. But prior to 18, the DHS, in all their wisdom, sent this child to I forgot what it would be called. Anyway, there the child associated with other problem children. And so when the child turns 18 and all these other children got out of the same place as this child was I was talking about, they were friends. They became friends in this group home or wherever it was. But these kids also carried with them negative habits. And even though this boy that I'm talking about did not participate in these negative habits, but he did continue his friendship with them. And now, today, because those kids broke laws later, he is now in prison for 8 years, I believe it was, his mother said. All thanks to the DHS for how they've taken care of the situation while the child was a teenager. Thanks, DHS.
You were careful not to mention the home, because after all, that's a Toledo home for boys.
That's where it was. You're
okay.
right.
Which is an institution operated by the Department of Human Services. So watch it when you speak ill of something the DHS is attempting to do to help these children, to help them into
Congratulations, DHS.
you bet. I want to turn real quickly here to one of the um, activists in the area of port reform. Um, Terrance Walker has spent a number of hours and days and weeks and months in researching areas in which we can improve our system of government, particularly in the judiciary. Reform, court reform, is one of the major areas of concern, not only to us, but to other individuals. And until the courts are straightened up, whatever we might try to do on a grand scale in child protection is going to be in vain. Let's listen to what Terrance Walker has to bring to us in today's session. Terrance.
Well, thanks for having me on the show once again, John and Don. I appreciate the opportunity to share with people my thoughts and opinions and other stories as they respect the judiciary in this nation. And I want to start right away with the story here. There's a lot of interesting things going on in Florida right now with the judiciary. One lady whom is a reporter for the WorldNet Daily, she offered her commentary on the state of the judicial system and lawyers as well. And what she said, what her name is Barbara Simpson, and she's the babe in the bunker, she calls herself. And she says, get rid of lunatic judges and lawyers. She says this in May 15, 2006, WorldNet Daily exclusive commentary. Remember that line from Shakespeare? Quote, first we kill all the lawyers. And Barbara says, he should have said judges, but don't let the lawyers off the hook either. Two decisions in California last week are examples of things that are out of control. The lunatics are in charge of the asylum and the opinion and desires of the people. Yes, citizens who work and pay taxes that pay for the salaries and dirty deeds of those legal misfits mean absolutely nothing. On Thursday, a lawyer-sponsored bill passed the California Senate. It would homosexualize all public education in the state, K through 12, by requiring all curriculum, textbooks, teaching materials, and school-sponsored activities teach about and endorse all gay lifestyle and identify people by their sexual activity so that gay contributions to the culture can be noted. Then, on Friday, a Superior Court judge in Alameda County, San Francisco area, threw out the California high school exit exam. He did it to allow high school seniors who have not passed the test to graduate with their classmates and receive a diploma anyway, even though by not passing the test they are not capable of passing 10th grade English and or 6th, 7th, or 8th grade arithmetic. And I thought that would be I don't have anything against the gay lifestyle. I'm not gay though, but some people I guess are happier than others. But anyway, the interesting commentary that I would like to make on it is that I could see her point. Why would you at the same time say, well, it's okay for us to teach this and have this in our classrooms, whatever it is, gay lifestyle, whatever. But at the same time, something that's so fundamental like arithmetic, English, things that are going to serve to better enable a person to compete in the job environment, in the entrepreneurial field. You're not going to require that, but at the same time, you're going to teach the gay lifestyle. And that I'm sure that has some importance, but at the same time, the fundamentals I feel are more important. And this is the kind of thing that we've been seeing here the past several years. These very striking contradictions that are coming down out of the courts, unreasoned, unsensible opinions that are very contradictory. Why would you not require the fundamentals, but at the same time you're going to teach about gay, whatever, and it just doesn't make any sense to me. Did you have any thoughts on that, John or Don?
You said you aren't gay, but yet I heard you laughing earlier. So I think you are a gay man.
Oh
You're
no!
happy at
Now,
times, Terrance.
there you go.
Well, that's what the word gay means, isn't it? To be happy.
Well, I wouldn't choose to use that label in reference to myself, though.
That's what
I
I
don't
grew
care
up
how
with.
happy I am. I like women quite well, thank you. But on to the next subject here. Boy, it's getting hot in here. I think the powder girl took off the day or something here. But
They took a powder.
yeah, they took a powder. Another interesting story about judges here, well, not here, but in Florida. This is from the Miami Herald. Fred Grimm reports, judge is either quite mad or downright mean. And he says, our judiciary has divided mental disorders into two stark contrasts, ours and theirs. Judge John Sloop clearly suffers from a mental defect under the heading of ours. Sloop has described a kind of self-diagnostic epiphany one night last year while watching a TV bit on an attention deficit hyperactivity disorder. Good thing he was paying attention. Attention deficit hyperactivity disorder has become the bulwark of his argument that the Florida Supreme Court ought to let him keep his $131,000 a year job. Wow, that's a lot of dollars. $131,000 a year. The famously mean Seminole County judge told Judicial Qualifications Commission in Florida that his latest fit of nastiness, tossing 11 people in jail after they had been directed to the wrong court, was due to his newfound mental disorder. Sloop, 16 years on the bench, has previously been rebuked for waving a pistol around his courtroom, verbally abusing defendants, and charging defendants $50 for each night they spent in jail. He had promised the Judicial Qualification Commission in 2002 that he would cause no more problems. A burst of ill temper on December 3, 2004, got him into trouble again. He ordered the arrest of 11 defendants, all facing minor misdemeanor traffic charges, who missed the court dates. Sloop was told by deputies and two other judges that, in fact, the 11 had been directed to the wrong courtroom that morning. Sloop signed their arrest warrants anyway. The 11 were led away in chains, strip searched, and tossed in jail for 8 hours. Sloop explained to the qualifications panel that he now knows that it was that ADHD that was causing him to misbehave. Quote, I was struggling with an undiagnosed disorder, he said. His disposition is laden with enough language of self-realization to land him a guest appearance on Oprah. He now speaks as an ADHD survivor. He explains his long history of bad behavior as coping skill, albeit one appreciated by the 11 folks he tossed in jail. Suffering from ADHD, said the judge, who has been transferred to civil court, has been like living in a fog where you don't quite feel in sync or connected. Poor Judge Sloop. Though one wonders how many of the 10,800 mentally ill inmates languishing in Florida's jails might argue that too. Have they been living in the fog and not quite in sync? Except, of course, the judiciary files those disorders under theirs. Sloop's fellow Florida judges are notoriously unsympathetic to defendants whose mental disorders contribute to criminal transgressions. Eddie Cruzan, known as Crazy Eddie, suffered a long history of mental illness. He was suicidal, and he told doctors a fantasy to kill his mother. Right after he was released from a mental hospital, he did that. But when he was tried on first-degree murder charges in Broward County 10 years ago, his craziness was not crazy enough to sustain an insanity defense. He was convicted of first-degree murder. Last month, the U.S. Supreme Court heard the case of Eric Michael Clark, a paranoid schizophrenic who believed his parents to be space aliens. His long history of mental illness didn't matter in his murder trial either. Florida judges in particular packed prisons and jails with pathetic, lost, delusional, raving mad inmates until county jails house 3 times more mentally ill inmates than the state's psychiatric institutions. Like Dana Clyde Jones, 44, who has been in a coma since he was beaten up in the Broward County Jail on December 16th. The plight of Jones, whose mental illness became tantamount to a death sentence, and so many other truly disturbed prisoners, makes a jarring contrast to the psychological defense offered by Judge John Sloot. The Florida court will decide whether a TV inspired diagnosis of ADHD excuses a judge of downright meanness. Well, at least they're doing something down there, and I hope they do find that this guy is crazy and get him off the bench. I think that's what they need to do to that. And speaking of crazy judges, and maybe I shouldn't say that, but we had the privilege of having visited some of the judges here at the Iowa Supreme Court House in Des Moines, and they had a interesting open house there. The second annual open house. They call it now a conversation with the courts, court staff, judges, and the like of both the Supreme Court and the Iowa Court of Appeals were there. Well, most of them there. I think Judge Terrance had to go to a soccer game. But these are the judges that we got to meet. Some of us got to meet some of the Court of Appeals judges and some of the staff for the
She went to a
judges as well.
soccer game, you say? I thought she was there to hear the cases.
Well,
No wonder it takes so long to get her cases
well,
heard.
soccer has precedence over open house, obviously.
Open house, there's a lot of people waiting for their case to be heard.
Well, that's
6
how
months,
we-
a year?
This was an extracurricular activity, though.
Oh, really?
Yeah, yeah. This wasn't required. I guess.
Elective.
But I will say this. You usually hear me talking about some of the judges and their opinions. I will say this, that it was an interesting event, and it was kind of interesting getting to see the judges interact in a different dynamic than they normally do. And that's one of the things I shared with this judge, Judge Katie, who's a Supreme Court justice, because oftentimes when you see them in court and they're in their black robes and they're so stoic and they seem so cold and distant and stone-faced, you're like wondering, is this guy for real or is he Memorex? But this guy was really it's Judge Katie, who's actually from Fort Dodge. We did get it. Did get to take a tour with him, and we got to see a lot of the court facilities and some of the stuff that's not normally open to the public. Their offices, the clerk's offices. They had some really nice offices, a lot of wood grain, cherry wood around the place. It was a really interesting building, And like John Harvey calls it, the $30 million marble mansion. And we make fun of that a lot, but Judge Katie explained the reasoning behind that. The reasoning why they needed that facility was because they were leasing out a lot of office spaces downtown, and it was, I guess, it was a little bit inefficient as far as handling court business to have not only the judges and the court staff in different places, but it was also inefficient monetarily wise, I guess, to have all these people in leased spaces down at another location that would have to travel back and forth. So, I did get to explain that. And one interesting side note, we did get to see, I did get to talk with him at the end, the presentation of what he showed me, this chief judge's office, who interestingly also looks over a burial site for the guy that donated the land for the building.
My name is Scott.
When
Yeah,
did that happen? What year?
That was really interesting. I don't know how long he's been dead, but it just, it's just kind of funny, if you donate some land and they put you right there and they look at you every day. I mean, I don't know. I don't think I'd want to be in that predicament, but be dead and, the judge looks out the window at you every day. Oh, there's old dead Scott, whatever. But it was just really interesting, and for the most part, the judges that I did get to see live and in person, Judge Lavarado, I call him Lavarado. I don't think he realized that I was the one that also calls him Lavarado, but He was pretty cool guy. Judge Carter and Judge Katie, who was what I got to see, and you got to see a couple of the other ones, didn't you, John?
Yes, Justice Wiggins.
Justice Wiggins and Judge Strike, who was there. I always call him Judge Straight because I didn't know how to pronounce his name, but it was Judge Strike, who was also there. He was talking in the main oral argument room. And boy, that's a high tech facility. They got cameras, voice activated cameras on each one of the judges, and when they talk, it redirects to them, and they have an overflow room with the projection TV in there or something to that effect, and it shows all the interactions of the oral arguments, and they're recorded and they're put online on the Iowa Supreme Court website. Got to really discuss some of the technical and the architectural aspects of the building. Didn't get into the real uh, judge of the judges type of information, but I did get to at the end of the presentation, which Judge Katie was showing me around, and I even got to walk back behind where the judges sit and down the corridor where they walk down before they go out and sit and listen to oral arguments.
And you're the
But
judge of the judges, and
that's
they
right.
treated you with respect.
Well, that's right. They have to because I am the judge of the judges. I'm not going to demand. I'm not going to accept anything less than that. So we you're laughing. You're
They
laughing.
the servants, you the master.
That's right, baby. But I just want to let everyone know there that I'm not selling out because we are going to still be critical. I'm a skeptic. I'm still a skeptic, and we're going to be hounding these judges until they get it right here. But I think it's a good thing, good change to have open venues, kind of to just demystify the whole court spectrum and the judges and the whole courthouse and the procedures and whatnot. But as we observe on this show week to week, some of the opinions coming down, just sometimes they don't make any sense. So I mean, we're still going to be on them until I get it right. And Judge Katie, interestingly enough, when I told him that we do he must not get to watch the show up in Fort Dodge, but he did say that I was welcome to give him a call anytime. And so I'm going to take him up on that offer, and we're going to see if we can have him on the show and do an interview. And we're going to talk about some issues that pertain to court reform and perhaps judicial immunity, perhaps voting out some of the judges, and some of the other issues that we've been tackling over the past year or two that I've been on the show. And, see if we can come to some interesting dialogue. So we're going to still be really pressing the issues because I ain't no sellout. We did meet and get to peruse with the judges or whatnot and get to intermingle with them, but I'm still not convinced that that everything is okay. One individual that appears to be nice, that does not sway me one bit. Because a lot of times it's the outer package can often be very deceiving.
The proof
So
is in the rulings.
there
Isn't
we
it?
go. Exactly. So I don't know if there's something wrong with the judges or the clerk system or the whole process in which they decide or issue these cases, but when you have some cases that really don't add up and there's missing issues and there's missing logic, I think there's something that's still terribly wrong with the whole system, and that's more what it's about than a nice friendly face.
That's right.
That's my 2 cents on the whole issue.
This building for the judges, it's located almost straight south of the Capitol, across the street, isn't it, Terrance?
Yeah. Yep. And it's a beautiful building. I wasn't really there to see the building, but it was nice to see some of the different facilities and some of the high-tech features of the building and all that. I mean, they really got some type James Bond type stuff back there. I went into the room where they discussed their opinions or discussed the way they're going to rule, and they had these little square things on the table, like 4 of them, and I said, well, what's those little square things on the table? And Judge Katie pushed some button and said Zzzz, and it had like a little plug system so they can plug in their computer, they plug in their Ethernet cable, and You know, they can sit there with their laptops if they want while they're sitting there debating. It's kind of interesting. But yeah, it was just really high tech, really nice building. But you know, like I said, we're gonna get to the real meat when we talk with Judge Katie here in a week or two, and hopefully he's available that week because he travels back and forth from Fort Dodge a lot to come down here to decide these kind of things.
What did the building cost? Do you know?
I think it was somewhere along the lines of $30 million, and Judge Katie told me that it was about the same time as the tobacco settlement that Iowa had negotiated, and they used some of that tobacco settlement money to kind of pay for the building or whatnot.
Tobacco settlement. I thought that settlement had to do with people that lost their lives or something, and so that money goes into different things, doesn't it?
Well, that's what I was told. I'm just telling you what I was told. I'm not.
Well, I'm
We
glad.
could debate that, I guess. If you want to debate that, I'm sharing with people what I was told. If you find something wrong with what he was saying, then maybe we need to discuss that.
You're
know?
right.
But yeah, I did think that a lot of that was supposed to go to some of the victims or their family. But you know, I guess part of that was also to go to pay for ongoing medical expenses incurred by the state. So
Right.
I guess there's some really weird questions there. If that's the case, if we've got money going to a building, it's supposed to go to victims, but who knows? I don't know how it was supposed to be divvied out, so I really can't say anything else. I'll research that, and I guess we'll get back. We'll get back with Judge Katie on that when we have him on the show.
You bet.
But did you have any other comment about that? I know you were down there too, John. I actually bumped into you and we talked for a second.
Right. Well, I noticed that they're not terribly excited about collecting books like some of these courthouses used to, because now everything is online. And
Yep.
so even though Katie has a bunch of the books behind him there, the number of books they have are few and far between now. In fact, I noticed in their so-called library, it was only shelved about 1/3 of its, yeah, probably not even a third of the shelves were filled with books. They don't need them anymore because everything is online. Did you notice also there was a 5-story atrium in that building, an atrium like no atrium I have ever seen, because the building is built around a square 4 or 5-story patio. I think they have some secret rooms up on the 5th floor. You're just not permitted up there.
We're not permitted up there.
I think there are sleeping quarters up there for the out of town justices. And next time you go, Terrance, you should go around the East Hall and see the private elevators that the justices have, so they can get down to their underground automobile storage and
Wow.
and whisk out of the place without
Out
anybody.
the Bat Cave.
Yeah, right. You bet. Well, there is a story that of interest here. It has to do with child protection. I wonder where the social workers were in the Lozano case. Do you suppose she would have starved to death in a day or two, or would she have starved to death if she was seen by a social worker on time? I wonder why we have a social welfare protection system, and still we have children dying all over the place. I won't take any particular judgment in this case, because anything that I might say would be in the area of speculation. But there are some concerns that rise here. Number one, they seem to take a real interest in the fact that the child was underweight, and that she was only, I think, the 16th percentile as far as weight is concerned. Why would that even be considered at all? And another thing I can't understand is, if this mother was deficient in her skills, why does it take a month to come to that conclusion by an investigation team as to why this child? It seemed like to me you ought to be able to deduce that in an hour, whether or not the mother was deficient in her parenting skills. They may not have liked the mother, and maybe that figured in a whole lot too. Don, can you just briefly summarize what we found here in Johnston, Iowa. By the way, that is also the location of a little boy who died who was also underweight, 66 pounds, and in the sixth grade. Who killed Alan Griffin? So maybe these things are still haunting the area of Johnston, Iowa. Who killed Alan Griffin? Nobody killed Alan Griffin. They just didn't have the kind of medical talent in Iowa to know what was wrong with
Especially when
Alan
the
Griffin.
doctor was on the golf course, wasn't he?
The specialist was on the golf course, yeah, when he should have been looking after that young man. The fellow was active. He was in sports within the same week in which he died. So it was rare disease that he died from, but we didn't have the medical talent. We had the medical talent to help the prosecutors, but we didn't have the medical talent to help the children. Isn't it a shame that we can have talented people helping in prosecution, but we don't have talented people who can help children like Alan Griffin and this little Lozano baby? I didn't leave you very much time there. Maybe you can just give us a brief explanation there, Don. See what you can do with that.
I've got an article in front of me written by Abby Simmons, registered staff writer, and I took now we're back to the where this 3-year-old they're allegedly accusing this mother of starving this 3-year-old to death, and in this article down and toward the bottom it says at the time of death, Consuela, that's the 3-year-old's name. The mother was also raising 2 other children, age 4 and 5. These children were properly fed, so they were healthy. So it wasn't that the mother didn't have the talent to do it, because the other children were properly fed. I'm going to start reading here to the end of the program, John. A metro area mother faces a first-degree murder charge following a month-long investigation into what authorities call, quote, by far the worst, unquote, case of malnutrition in a child. Johnson police said Lorenzo, 25, intentionally underfed her 3-year-old daughter until the girl died in late March, weighing only 12 pounds. A normal child at that age should weigh at least twice that. Well, keep in mind, in different families, there's different sizes of children. We've seen that before. You look down the street, there's short people and tall people and big people and fat people. Anyway, the article goes on. I've never seen a case with this much in the way of wasting away that wasn't due to some kind of natural disease. Consuelo was pronounced dead at the scene after a death investigation by the Metropolitan Investigation Team. Okay, John, I'll turn it over to you.
Okay, thank you. We'll see you next